Hello, everyone, and welcome to our third panel. We're going to be focusing on three quite basic issues in the area of animal law: legal status, standing, and enforcement. And the three panelists that we have on this panel are experts in these respective areas. So we begin with David Favre. He's the professor of law and the Nancy Heathcote Professor of Property and Animal Law at Michigan State University here in the US. And he will present on living property, new legal status for animals. Take it away, David.
Thank you. Thank you, Joan. Thank you for the invitation to be part of this project. Back in the 1990s, Steve Wise and I got together and were thinking about we need to do something that is more jurisprudential, something that is deeper than just thinking about immediate cases and that sort of thing and reading statutes. And so we started down that line. And the first division point that we came to was the realization that while initially we thought that the issue was standing, we decided that it's not standing. There's a step before standing that isn't talked about very much because almost all cases are humans and already have personhood taken care of, so the courts don't ever really talk about that. But if you don't have personhood, then you can't get standing. Delcy's going to talk about standing itself, and I'm going to step back a little bit from that point of view. And when we get to personhood, we have that fundamental legal and ethical concern that was very in the forefront in the 90s, even in the 80s, for lawyers, and that is animals are property. And they've been property ever since we've had any level of sophisticated legal system. And why are animals property? Well, because they're useful and they have financial value. And all legal systems, all legal systems seek to produce rules that allow society to move forward by having rules about if something has value, you want to sell it, you want to buy it, you want to do things with it. What are the rules for that? So the Uniform Commercial Code is a critical component of our legal system because it tells you how you move property around. All right, well, obviously none of us are happy with the idea of property because that says that it's no different than a toaster or a table in the eyes of the law, even though it's so different for us. And so what do we do about that? Well, in the 90s, the ethicists said, well, we have to remove the status of property. We have to make them not property. Well, as a property professor, at that point for 20 some years, I was thinking, well, what does that mean? What is not property? And I couldn't come up with an understanding from a jurisprudential point of view about what not property might be. And indeed, the Swiss decided to do something for animals by saying in one of their constitutional revisions that animals were not property, but that all property law would apply to them unless otherwise dictated. So I didn't find that particularly helpful. And yet I certainly agree with the idea that we need to move them out of the category of property. And so I came up with this concept, this bumper sticker phrase, if you would, of living property. And most people in the animal movement were simply not happy with that because the word property is still there, right? So it has that negative taint to it, to those of us trying to get change. But my thought was, I'm not worried about the animal movement. I'm trying to figure out how to, in the world of jurisprudence, in the world of courts, in the world of legislatures, what would be a first step, because there's no way, nobody's ever suggested to me how this is possible, to eliminate the property status in one step. It just isn't going to happen. Well, if that's not going to happen, then is there no step forward? And no, I didn't think that was the case. That property law is malleable. It's been changed century by century, not in huge leaps, but it does change. The status of women and the capacity to hold property is an example that took centuries to change, but has now in the US and almost everywhere else been changed so that there's no longer a distinction between a man and a woman holding property. Um, and so I want something that will not cause red flag warnings to those of us that are not to those that are not in the movement by saying free the animals, animal rights, those phrases just cause automatic negative reactions in a lot of people. Enough people so that I think that what we need to do is have a box that has a relatively neutral name to it. It is different, and then just simply work with that name and make it a robust box. I'm making a box, and that box is going to have this label on it, living property. All right. And then we can think about more specifically, how do we get more animals, more rights in this box? Okay, and that allows us to break down the question into not trying to figure out how to get all animals free or all animal. Well, I don't know what the other option is, and instead talk about, well, what can we do about dogs and cats? What can we do about animals in toxic research? What can we do about, and of course, the biggest one ever out there is farm animals. One of the things that we have to sort of think about, if the idea is to put in place conceptual ideas that allow animals to have rights, we need to think about what rights mean. And with that, I'll just, this is my little bitty nutshell on rights. Obviously, people have written many, many books on this. I use Roscoe Pound's theory of jurisprudence, which says that the purpose of law at its base is to accommodate and deal with conflicting interests between the members of that society. And so it's an interest-based analysis. And humans have interests, so it's easy to say that humans are legal persons. And then we've done things like say that a city is a person because a city has interest, which really is the interest of the citizens, so it really is still a human-based interest. But we'll conceptualize it up to saying that a city has a personhood too. And same with corporations. Corporations have personhood. Well, why? Because they represent the interest of humans. Now we want to say something a little bit more sharp, that we want animals to have interest, not because of our interest, but because of their inherent interest. Okay? So how do we get their interest into the legal system? That's the key, into that box. How does that going to happen? There are two steps about putting something in the box. One is first getting the category of animal into the box. Are we talking about butterflies? Are we talking about cats? Or what are we talking about? Which animal is going to go into the box? And the whole point is we don't want to try to find a path that puts all animals in the box at one time, other than the cruelty laws that we now have and have had historically. Obviously, that in theory applies to all animals. But otherwise, I think the path forward is to find particular categories of animals and find a particular legal right that represents their interest. Well, what might that right be? I have a couple of quick examples of where we are today with that. The first is with wills and trust that are now in all 50 states. This is in one of the most conservative areas of property law, wills and trusts. They were the breakthrough area that said, no, we're now going to allow a trust to be created for an animal. And it's to be enforced by any person who sees a violation, and there must be a trustee that has it. And if the trust is not being carried out in accordance with its terms, I can bring an action on behalf of the animal, but it's the animal's interest that is at question, not my interest. I can just simply be a best friend for the animal to enforce the trust. And that has now part of general practice everywhere. All people that have clients with a fair bit of money and animals that want to be protected, it's going. There's almost no litigation in this area. It simply is working. Another example of where the interest of the animal can all of a sudden stand out and be part of the legal regime is in divorce law. And previously, animals were property, and therefore, under the rules of property, the animal was distributed to whoever owned the property. And starting with Alaska about 3 or 4 years ago, and now I think with 5 states, we have in place a law that says in a divorce proceeding, a judge has the authority. In some states it's not mandatory, in others it's a little more mandatory sounding, has the authority to decide what is in the best interest of the animal, not who owned the animal or who's crying the loudest for the animal, but what about that animal? Let's look at the animal. What's important to the animal? And frankly, it gets pretty close to what's important for the placement of a child, a human child. It's the same sort of interest because who can best provide for them, who has an emotional contact with them, all those sorts of things. And so now we have companion animals in the box, and in a context of divorce, they get to have special awareness and treatment. So that's an example I think is now cutting edge, and I don't see any reason why that won't proceed across the various states and end up being in all 50 states, but it may take a decade for that to happen. Now, you might also want to ask, well, why is that happening? I've always argued that dogs and cats are going to be the threshold species for the creation of rights, and that is because they have political standing that's unmatched by any other set of animals, even chimpanzees. Because chimpanzees are the most like us, and that's why Steve Wise proceeded to bring a whole series of litigations about chimpanzees, because he wanted to make the argument, well, they're so much like humans, they should have the same level of standing or of personhood within the legal system. But you notice the courts have not been willing to do that, and it's been a large number of cases now. And it's because although the judges often are sympathetic to the idea of the chimpanzee moving into the box and having rights, that they don't know of a way to limit it to the chimpanzee. And so the question always comes up, where do we draw the line? If we let the chimpanzee in the box, how do I keep out the rats and the butterflies and the other whatever silly thing they want to talk about? And the answer is that in a court opinion, there is no way to simply say, unlike legislation, this legislation is about dogs and cats. You can't have a case that says it can only be used for primates. And so that's why I think we've had failure in the courts at this point in time for doing much. And instead we go to the legislature. And so the question is, what can we do for animals in the legislature that the legislature is willing to talk about? Or a great alternative is the ballot measure, where you ignore the legislature and you go directly to the people. And Proposition 12 in California may be the strongest and most important example of where at least cage size issues has now been given, and those animals have a right to that size cage in California and anywhere they're raised if the meat is sold in California. So that's the ballot, and it went through the 60% plus, I think, on a ballot initiative, and I think that may be the best path forward that we talk about. But in the legislature, you can draft a law in which the legislators can be comfortable that they're not doing anything which in their judgment is crazy or pursuing animal rights. If you go in and say, I want to write a bill for animal rights, and immediately every group that's a lobbyist for all the billion-dollar corporations jumps up and says, oh no, we can't do anything that says animal rights. Don't ever use the term animal rights. Instead, go in and say, listen, we think it's unfair. I want to be able to take care of Fluffy when I die. Now, what's wrong with that, and why can't we take care of that issue? And a legislator thinking about Fluffy, who also happens to have Bosco at home and has the same generic idea that, yeah, it's your animal, and you should be able to provide for it into the future. So that's not a great big political leap for them. So I see Joan is arriving, and maybe I need to wrap it up. And so let me just leave with the thought that I think I've created a box. Don't ever tell the legislature about the box, but go forth and try and find examples of projects and legislation that you can do to put some animals with some rights into the box. Thank you.
Thank you so much, David. That was really, really helpful. And we will look forward to some additional questions when we finish up our panel. Thank you so much. All right. Well, now we're going to turn to our second panelist. Um, Delcy Winders is an associate professor of law and the director of Animal Law and Policy Institute at Vermont Law and Graduate School. And she's going to be discussing legal standing, access to the courts in the United States. So, Delcy, would you like to join us?
Thank
Hi,
you so
thank
much.
you so much.
Yeah, thank you for having me. Thank you, everybody, for taking time out of your day to join us. So, I'm first going to talk briefly about what legal standing is. Then I'll talk about standing requirements in US federal courts and the key ways that animal advocates have been able to satisfy these requirements. I'll then turn to the question of standing for animals themselves in their own right and address how courts have addressed that issue. So, starting with the question of what is standing? Standing is, put simply, the capacity to bring a lawsuit. That's it, nothing more, nothing less. So Article 3 of the US Constitution is the source of authority for our federal courts. And Article 3 says that that authority extends to cases and controversies. It does not, however, tell us what cases or controversies are. And so the Supreme Court has stepped in to answer that question, and it has, in recent decades, developed a three-part test for that. So the Supreme Court tells us that the irreducible constitutional minimum of standing is injury in fact, causation, and redressability. So under the current case law, if you cannot show all three of those things, you lack standing. So just to summarize, you have to show one, an injury in fact that is caused by the challenged action or inaction. And third, that a favorable judicial decision is likely to redress. Of these three elements, the Supreme Court has defined injury in fact as the first and foremost element of standing. It's what most often gets litigated, and it's what I'm going to focus on today. So, how can animal advocates pass this test? What kinds of injuries suffice for constitutional standing purposes? The first key one for animal advocates is aesthetic injury. That is injury to one's interest in seeing animals, including seeing animals in humane conditions. So the first aesthetic injury case is Sierra Club versus Morton. And there the Supreme Court established for the first time ever that harm to the environment, to scenery, and to wildlife that one enjoys observing, those harms to your interest in observing those things are cognizable injuries for the purposes of standing. Then in Lujan versus Defenders of Wildlife, the court strengthened this and said, quote, of course, the desire to use or observe an animal species, even for purely aesthetic purposes, is undeniably a cognizable interest for purposes of standing. And, quote, it is clear that the person who observes or works with a particular animal is threatened by a federal decision. The particular animal threatened by a federal decision is facing perceptible harm since the very subject of his interest will no longer exist. So you're probably noticing this is pretty human-centered, but it's a pathway for animal advocates. And so building on this Supreme Court precedent in Animal Legal Defense Fund versus Glickman, the en banc DC Circuit held that an animal control officer had standing where he saw primates at a roadside zoo in inhumane conditions, and he continued to visit those animals. He was distraught by their conditions. He was concerned about them. He was reporting those conditions to no avail. The court noted that the case law clearly establishes aesthetic injuries suffice for standing and said this animal control officer, quote, suffered direct, concrete, and particularized injury to his aesthetic interest in observing animals living under humane conditions. Then In ASPCA versus Ringling Brothers, the DC Circuit held that aesthetic injury includes an emotional injury that a former Ringling Brothers barnman suffered as a result of mistreatment of elephants, with whom he developed a very close relationship. So he had left the employment of Ringling Brothers because of the abuse and neglect he witnessed, but he could still see these elephants, who he called his girls, by going to the circus. But even there, he could observe the signs of abuse and neglect. And so he faced a Hobson's choice of either not seeing his girls at all or seeing them suffering, showing signs of abuse. Either way, the court said he would suffer an aesthetic injury. And so the court said his suffering from the mistreatment of the elephants, to which he had become emotionally attached, was a cognizable aesthetic injury. So based on this series of cases, animal advocates have successfully demonstrated standing based on aesthetic injury in numerous federal courts, success with pretty good success, particularly in the context of animals who are on exhibit, because those are the ones we can most readily observe. It's much more difficult when we're talking about animals who are kept behind closed doors. Okay, that's aesthetic injury. The next key way that animal advocates can get standing is organizational standing, sometimes referred to as haven standing, not to be confused with associational or representational standing, which is where an organization can stand in on behalf of its members based on their aesthetic injury. Organizational standing is different. It has nothing to do with aesthetic injury, and it's premised on a different kind of injury that is an injury to the organization itself. And so the Supreme Court recognized this type of standing in a housing discrimination case where the plaintiff organization's work was frustrated by the challenged racial steering practices, and the plaintiff organization had devoted significant resources to both identify and counteract those challenged racial steering practices. The court said there's no question that this is injury in fact, and that if a defendant harms an organization's activities and the organization devotes resources to counteract that harm, the injury requirement of Article 3 is met. So this too has been a key way for animal advocates to show standing, particularly for organizations rather than individuals. However, last year, in the mifepristone, the abortion pill case, the Supreme Court held that the plaintiff organization did not have standing. In doing so, it didn't get rid of haven standing completely, as many of us feared it would do, but it nevertheless took the opportunity to seem to cabin the scope of haven standing. And so it said, an organization has not suffered a concrete injury caused by a defendant's action. An organization that has not suffered a concrete injury caused by a defendant's action cannot spend its way into standing simply by expending money to gather information and advocate against the defendant's action. And it went on to say havens was an unusual case, and this court has been careful not to extend the havens holding beyond its context. So it largely remains to be seen how the lower courts are going to interpret and apply this decision. And animal advocates are proceeding more cautiously than ever before with this theory, but there have been recent decisions recognizing haven standing for animal protection organizations even after this Supreme Court decision. So it is still an available theory. Okay, what about state courts? State standing requirements vary by jurisdiction. States are not constrained by Article 3 of the US Constitution. However, most states have adopted the federal standing requirements. Importantly, though, unlike federal courts, most state courts allow for exceptions to those requirements. Some don't have those requirements at all, and some states have by statute granted standing to animal advocates. Most notably, for more than half a century, North Carolina has had a law that authorizes any person to bring suit to enjoin animal cruelty without any requirement that they show an injury. So that's standing for human animal advocates. Those are the key ways, not the only ways, but the key ways that they obtain standing. Let's look at the question of standing for animals in their own right. So the first case examining this question was a case brought on behalf of the World Cetaceans, challenging the Navy's use of sonar, which is well documented to injure cetaceans, disrupt fundamental behaviors such as eating. On the question of whether the cetaceans had Article 3 standing, the Ninth Circuit, to the surprise of many of us, said yes, they have Article 3 standing. The court said, quote, nothing in the text of Article 3 explicitly limits the ability to claim and to bring a claim in federal court to humans. The court continued, it's obvious an animal can't function as a plaintiff in the same manner as a juridically competent human being, but we see no reason why Article 3 prevents Congress from authorizing a suit in the name of an animal any more than it prevents suits brought in the name of artificial persons, such as corporations, partnerships, or trusts, and even ships, or of juridically incompetent persons, such as infants, juveniles, and mental incompetence. Great so far, but the court next turned to statutory standing requirements, which I haven't mentioned yet because they tend not to be an issue in the context of human-animal advocates. They're interpreted very liberally, but not completely liberally. So sometimes statutory standing is referred to as prudential standing or zone of interest standing. And what this requires is that the plaintiff's injury fall within the range of interests that Congress intended to protect under the statute that forms the basis for the lawsuit. And in cetacean community, the court held that none of the statutes that formed the basis of the lawsuit, since the Endangered Species Act, Marine Mammal Protection Act, Administrative Procedure Act, none of those statutes contemplated giving non-human animals a cause of action. And the court said, if Congress and the president intended to take the extraordinary step of authorizing animals to sue, they could and should have said so plainly. Okay, fast forward 14 years, and now another animal is in front of the Ninth Circuit. This time it is Naruto, who took the very famous series of monkey selfie photos. And this is a copyright suit asserting that Naruto was the author of the photos and therefore under the Copyright Act owned the intellectual property rights to those photos. So the court first looked at Article 3 standing and it reluctantly applied the cetacean precedent. It said, we believe cetacean was incorrectly decided, but it's binding circuit precedent that non-human animals enjoy constitutional standing to pursue claims in court. Here again, the court went on to look at statutory standing, this time under the Copyright Act, and the court said the Copyright Act does not authorize animals to bring suit. So, like the cetaceans, Naruto had constitutional standing, but not Article 3 standing. Okay, let's look at the state courts where they're not bound in the same way as the federal courts. In a negligence per se case premised on violations of the state cruelty law brought on behalf of justice, a severely neglected course, the Oregon Court of Appeals said, first, under Oregon law, current Oregon law, only human beings and human-created legal entities are persons with rights and the capacity to sue. Therefore, justice didn't have statutory standing. However, the court also said, we emphasize that our decision does not foreclose Oregon law from ever recognizing an animal as a legal person or entity, but also that the courts are not the proper forum to achieve that goal. In other words, similar to the cetacean court, if the legislature wants to grant standing to animals, it can, but it's got to be the legislature. In a decision from the other side of the country that same year, 2022, in a habeas case brought by the Non-Human Rights Project on behalf of Happy the elephant, who's held alone in a tiny enclosure at the Bronx Zoo, New York State's highest court said, first, that the writ of habeas corpus, although flexible, is not so flexible as to extend to a non-human animal, and thus essentially Happy lacked a cause of action and therefore lacked standing to bring suit. Here too, though, the court signals, though not quite as explicitly, that advocates should go to the legislature to seek standing for non-human animals. So just to conclude and summarize, The current state of the law in the US is first, federal courts recognize aesthetic injuries to animal advocates, as well as injuries to organizations themselves, though courts are increasingly reluctant to recognize this latter type of injury. Next, state courts recognize similar injuries, and some states much more broadly allow animal advocates to bring suit without showing an injury sometimes. And as for animals themselves, no court in the US yet has fully recognized standing for a non-human animal, but federal courts have recognized constitutional standing for animals. And both federal and state courts have signaled that if the legislatures want to grant standing to animals, there's nothing that bars them from doing so. So the next era of animal law is likely going to involve efforts to pass legislation establishing standing for animals, perhaps, to go back to David's presentation, through ballot initiatives. And this is going to involve grappling with really difficult questions of which animals, in which contexts, and so forth. Questions that the courts have made clear they want the legislature to resolve. So thank you, and please feel free to reach out and be in touch.
Wow, Delcy, that was a fabulous summary of standing. Terrific. Thank you so much. Really great. All right. And now our final panelist on this panel is Michelle Welch. She is the Senior Assistant Attorney General, a Director of the Animal Law Unit for the Virginia Attorney General's Office. And Michelle is going to be discussing prosecuting animal crimes in the U.S. Thanks so much, Michelle.
Thanks, Jen. So we're going to switch gears as animals as victims, and what do we do about that? I think I loved Delcy's and David's presentations. I think they are the next frontier when it comes to animals and how we perceive them. But I'm living in the world of the criminal world and animals as victims, and what do we do about animal abuse prosecution? And so I think the first thing I'd like to say is that, we treat them as we would children. And we don't allow you to starve your children. We don't allow you to beat your children. We don't allow you to have sex with your children. We don't let you fight your children. So when it comes to animal prosecutions, there's 4 types. There's and NIBRS, which is the National Incident Based Reporting System of the FBI, has now started tracking animal crime. And there's about 4 different categories, and they are a good framework to what you look at when we're looking at animal abuse. First is simple and gross neglect, which is starving your animal to death, not giving them vet treatment, a whole host of neglectful kind of things you do. Then there's intentional cruelty and torture, which is much more violent, much more in what you intend to do to the animal. And there's all kinds of examples of that. There's also animal fighting, which is dog fighting, and cockfighting, which is rooster fighting. And this is an organized criminal element and an endeavor. And they're usually doing it for some kind of gain. And then we have animal sexual abuse. And so those kind of the 4 categories. I'm going to talk about things generally and not so much specifically get into each one. But when you look at an animal case, the first thing you have to figure out is seizure of the animals. And that's usually done with a search warrant. You have to have probable cause to show that there's some crime against the animal happening. So you go in, and I'm actually consulting right now on a case because they're going to be executing a search warrant. And so you execute that search warrant. And then you have to take care of the animals. You have to catalog them. You have to make sure that you put forward the best case that you can for the prosecutor. Many times, what I found, the problems are that people don't take this initial step very seriously. You cannot roll up into 100 cockfighting yard with 100 chickens and roosters and think that that's going to go well if you don't prepare. Same thing with dogfighting. You guys may have seen that Humane World, which is formerly HSUS, is on the ground, just finished a big dogfighting search warrant execution, and they're processing the animals. And so what I say about enforcement of this is to make sure that you take it very seriously. You catalog every animal. I've had cases where they just take one picture of all the dogs in that one kennel, and they don't specify dog number 1, dog number 2, dog number 3. So that makes it hard to prosecute. But the seizure of the animals is vital. You have to get that right, because if you don't win the seizure, then those animals go back to the perpetrator, to the abuser. And that is a failing. If you do that, they will also use that against you in any subsequent criminal animal cruelty case. I think what I like to tell prosecutors is that this isn't rocket science. If you can do any kind of case, you can do an animal case. I think what's different is that people, for some reason, think that you can just breeze in and do it like you would a simple petty larceny case on a general district docket. And that's where people go awry. I need you to treat it seriously. I need you to prepare. You have to be better than everyone else, because there is a bias against these cases. I've been doing this for 26 years. I have seen a real shift, and that's the hopeful part of my talk, is that many judges take it very seriously now. I don't know if it's because of my gray hair. I get a lot more respect than I used to when I bring an animal case. But I also think there's been a shift in our society that it's not okay to abuse an animal. I think most people believe that they need to be treated humanely. So I will tell you, I'll just give you one example of how it's different. I can remember sitting in a rural jurisdiction, and they had just done like a petty larceny case. And then there was a drug possession case. The 18-year-old was clearly addicted to drugs, but she had run out of compassion because they had given her break after break after break. And I remember I was the next case up, and it was a wildlife trafficking case. And I remember thinking to myself, well, I'm going to refer him to that case if he doesn't treat it seriously. I didn't have to worry, because that judge in particular understood the seriousness of wildlife trafficking and animal abuse, and treated it with the dignity and the seriousness that it needs. In prosecuting these cases, you want to make sure that you are prepared. Many times, because it's a misdemeanor, there is, especially in the prosecutorial world, there's a bias that, a misdemeanor is not as important as a felony. But when we're looking at animal crime, they're usually misdemeanors, because it doesn't always rise to the level of felony. And if you want a good resource to see what your laws are like, you should go to Animal Legal Defense Fund. It has a whole map. You can tap on your state, and you can find out what your laws are. But generally, most states have a neglect law, and then they have an intentional cruelty law. And usually, to get to a felony, it has to be a dog or cat. They don't usually afford that protection to a snake or an exotic animal or wildlife or a farm animal. That doesn't mean you don't have felonies, but for the most part, the more serious felonies are for dogs or cat. And so you're looking at misdemeanor animal cruelty most of the time. And what I like to tell people is you have to put on as many witnesses as it takes to win that case. I have put on 14 witnesses for one misdemeanor animal cruelty. I'll do it again. I do it systematically, and I do that because the animal and justice demands it. You want to make sure that you are prepared and that you are putting your best foot forward. And I will say, dogs and cats, I really liked what David said about they're the gateway to maybe personhood. But there is a bias for dogs or cats. Everybody wants, the death penalty if you hurt a dog or a cat. I do not get that same fervor when it comes to a snake, when it comes to an exotic bird, or if it comes to a cow or a horse or a chicken. And wildlife, for some reason, people believe that you can just do whatever you want without any regard to the wildlife laws that are on the books. They're very serious because wildlife belongs to the state, not to the person. So when you're looking at these cases, you have to take that bias into consideration, and you have to understand what you might get as far as punishment. And so what I also like to point out is that a conviction is a win. So many times people discount my hard work and they go, oh, well, you didn't even get any jail time. When it comes to animal cruelty, and look, I've been a prosecutor for 26 years. I've done homicides, rape cases. I have done any spectrum of case that you have out there. And it is a spectrum. And most of the time, you're dealing with someone who doesn't have a record at all. So the conviction is a win. I want you to understand that, because the conviction, especially if they're a frequent flyer, they will get jail time down the road. I had a famous wildlife trafficker who I got no jail time. I did get a ban, but later the federal authorities prosecuted him, and then he got jail time. So you have to consider that you want the conviction, because you want that person held accountable. And often the ban will get you as much as jail time. The ban will allow you, especially in a hoarding type situation, to get that person under control so that they stop abusing animals. Now, does that mean every single person I've ever prosecuted and only got a ban doesn't reoffend? No. But what it does mean is that it's a spectrum, and you want to be creative in your sentencing. And so that's just a little shout out to that. So I want to close with why it's so important to take these cases seriously. I had a dog named Minaj, and the vet was the reporter, and my animal control officer went out, and she reported because the story that the man gave did not add up. And what we indeed found out was that it wasn't just a slap. This animal had multiple fractures, some of them emergent, meaning they just happened, and then some of them being 2 days old, some of them older than that. And I asked this particular judge to let me put on an expert about the link between animal violence and human violence, and to talk about the implication for this particular dog. This dog had to be euthanized because they could not bring her back. Now, they blamed the vet. They said, oh, well, it's because of the money, but it wasn't about the money. It was more about the putting the animal out of its very blatant misery. And in this case, the necropsy showed that there wasn't any saving this dog, that it was as bad as the vet said. The reason I bring up this case is to show, intentional cruelty is something that we really do want to seek jail time for. Now, he did get jail time. He didn't get as much jail time as I thought, but we also did anger management. We also wanted a ban forever because it was a felony. And so these are the kind of things as a prosecutor you really want to examine, and you want to make sure that you get the justice that the animal deserves, and that you and you put an end to the cycle of violence or the cycle of neglect of the animal. And so I think I will stop there. I think I'm at 13 minutes according to my timer. I don't know. There's Jen. I would just the the news on animal cruelty and animal cruelty prosecution is good, because people are taking it very seriously these days, and that's what always gives me hope. So I will turn it to you, Jen.
Fabulous, Michelle. Thank you so much. And we're now going to be turning. This has been, and I want to thank all three of our panelists. This has been just a really fabulous, fabulous panel. And now we're going to spend, we have a few minutes here to answer a few questions. And we have our first question, I think goes to you, Michelle. How do you manage self-preservation when exposed to such cruelty and injustice? And I imagine, I know you've been doing this, as you said, for quite a few years now. It must be difficult, but and of course, a lot of folks in the movement, right, have to deal with these issues in a variety of contexts. But we want to speak to that a bit.
So I think self-preservation is making sure that you don't let the misery kind of define you or like envelop you. And so vacations are important, and turning off that phone. I've often been on the beach somewhere and an animal control officer calls me, and I've set boundaries now. I'm like, okay, do you need me right now? Because I'm on the beach. Can we talk in a week, or can we talk tomorrow? I will talk to you if you're on a search warrant and you're trying to get something done. But often, and I think ACOs, animal control officers, are really good at this, they respect you and they respect your time. The other thing is, if you are going through a period where it's really getting to you, you need to address that either with, talking to somebody, or my go-to is watching superhero movies where the good guy always wins, right? Like, I love a superhero movie. I love to watch them, and they give me hope. But that's how I've done it. There was a period of time when I also did sexually violent predator cases. And that was kind of a dark time, because the animal stuff I could put in a box, because I've been doing it so long. But having both was a lot. But I'd say you have to make sure you take care of yourself. And I think that's true, especially for lawyers all across the spectrum. I think we often do not take care of ourselves.
Thank you, Michelle. Here we have a question here, I think for everyone. Let me just read it up here for us all to hear. Given David Favre's framing of a core goal being to structure the law so that it can and will speak to animal interests, Michelle Welch's work enforcing laws that codify the interest animals have in not being subject to unlawful maltreatment at human hands, and Delcy's discussion of standing thresholds, I'm curious what thoughts the panel has on ways that interests of animals can be represented in criminal cases distinct from the interests of the state, individual owner victims, or defendants. So I'll let you decide who wants to sort of step in there and discuss that.
Well, one option is to intentionally bring in a third party who can speak on behalf of the animals, and this goes to what has been done in, I forget, Connecticut, where the law allows a law student or other person to step forward and be, in a particular case, a judge can ask for an outside person to come in and to talk about what is the interest of the animal here. How do we do this? So it doesn't, they don't get to argue in court, but they can file papers and they can bring to the judge's attention things, and they could look at sentencing proposals and make references that the animal needs to be taken into account, and what are we going to do about that? So in the midst of the criminal process, it is possible to create a group of people who could be spokespeople, let's say, for the animals.
I will just piggyback on that. We have done victim impact statements where we have someone come in and talk about the effect on the animal, and especially in dogfighting cases, and just being in, in the process, and the fact that they call them and they fight them, and they are dog aggressive, and just the systematic impact of that cruelty. So I echo what David said, but in a little different of a way.
And I'm going to explain why I focus on civil pathways, where standing is really important, as opposed to the important criminal work that Michelle does. I think it's incredibly important for both to be available to animals. I think the O.J. Simpson case is a great example of this. Normally, you've got a crime and a civil cause of action. So perhaps the jury acquits the person of the crime, as in O.J. Simpson's case, in part because the burden of proof is very high, but you still have the pathway under civil law, if you're a human or a corporation, to seek injunctive relief and other forms of relief. And that's so important for a number of reasons. One, because criminal law really is focusing on punishment, whereas through civil pathways, you can focus on getting adjunctive relief, removing animals, getting them into better conditions. Not to say that can't happen in a criminal context, but this becomes the focus. And most places, you don't have amazing prosecutors like Michelle, and prosecutors have discretion, and that discretion is considered sacrosanct. And so for animals currently, when they choose not to pursue a case, you don't really have another option. So that's why I think it's important to keep the civil piece on the table.
I agree with Delcy, because my seizure that I do first is civil. It's a criminal burden, which is insane in Virginia, but it's a civil process. I take them. I have the right to appeal that. So that gives me, like, when it comes to getting the animals out of this situation, civil is the way you have to go, because the criminal is what you said. That's holding them accountable.
Great. Thank you, guys. David, turning to you for a quick question. Do you see something coming after your living property paradigm has been accepted?
Well, I think something will come after this, and one term that's available, I'm not sure everybody likes it, but is guardianship, to sort of move us another step away from the property status. And as a guardian, you have an obligation for helping with the interest of the animal. So that I think is something we could talk about. I think most pet owners today actually consider themselves guardians. So if we wanted to put that in the law, I think that's something that's probably feasible. And then after that, I don't know. I'll be dead, and it'll be up to the next. These things happen over long periods of time, and I have to accept that I've put a brick down, and somebody else is going to come up and twice as smart as I am to figure out what the next 3 steps are, and that's great. So I don't know. We're after guardian. I'm not sure what the next step might be.
Thank you so much, Delcy. Let's think about. I was wondering what you think about the future of standing for animal advocates in federal court at this point.
Yeah, I'm very leery. And there was a 2021 Supreme Court decision, TransUnion versus Ramirez, that really terrified me, because there the court said to have an injury that's sufficiently concrete for Article 3 purposes, it has to be have a close relationship to a harm that has traditionally been recognized in American courts. So a very originalist notion of harm or injury. And I probably shouldn't be saying this in a public forum now because that actually hasn't been deployed as aggressively as I feared, but I think it's something that needs to stay top of mind. So I think organizational standing is very risky these days. I think we need to use it, but use it extraordinarily judiciously. Aesthetic injury seems to be on firmer ground, but I think in light of TransUnion, there are some real questions there. There's also just the overall increasing conservatism and originalism of the federal bench. And so I think we are probably going to want to be looking to state courts more and more.
Yeah. Michelle, what is the likely sentencing and then disposition of the animal in many of your animal cruelty cases?
So it runs the gamut. If it's a frequent flyer, I will get jail time most of the time. If it's violent, I will get jail time. If it's a felony, I will get jail time, especially for dog fighters. Cockfighters, I've only ever gotten a year, and that's a pretty much a record for the whole nation because they're chickens. Like there's just something about chickens where people just don't treat it seriously. I had a defense attorney once say, well, isn't cockfighting more humane than the processing plant? And I was like, well, if the processing plant is doing the job right, it should be more humane. The cockfighting is very inhumane, and they're basically bleeding out in the fighting ring. So it really depends on what it is. When it comes to the kind of animal, that really plays a part in it. If it's an exotic, people tend to not care unless if it's a very charismatic exotic. If it's a monkey, it's harder to get people to care. If it's wildlife, it's harder to get people to care. And so it really depends. If it's a hoarder, I just want to make the distinction about a hoarder versus everyone else. That always, you're going to want to get a ban. You're not going to be trying to get jail time on that for the most part. You want to limit the person's how many animals they have. And, it used to be, because I've been doing this a long time, we just take all their animals. And we know now you need to at least leave them with one or two so that they don't get back up and running. And often they don't even see the cruelty. And then there's wildlife traffickers who are like the most organized crime there is in this country. And then there's animal fighters, and I would put puppy mills. Like there's all this commerce associated with the suffering of animals. So again, trying to figure out what the best disposition is and whether the person has a record or not.
Yeah. Thank you. David, returning to you, how do wildlife fit into these categories of property? I know we've touched on it a bit, but you want to maybe just chat a little bit more about that?
Yeah, that's another category. They're not property, so they're not going to go into that box. So we need to have another box for wildlife, and it's sort of there again because like the Endangered Species Act has identified a set of wildlife that get some pretty serious protections. Not that we can't improve it, but and under the Marine Mammal Protection Act, some sets of wildlife get protections and considerations. So we are doing things on the benefit for the benefit of wildlife, but we don't really think of them jurisprudentially as a particular category or not. And I don't have a bumper sticker answer to that one because of the diverse commercial and personal interests that go into the human interactions with wildlife. Some we may think make sense in some ways, and there's cultural differences that come into play about the nature of the relationship between human beings and wildlife. And our Native Americans have a different cultural perception of wildlife than most of the other Americans in here. So how do you deal with that as part of the definition of what is wildlife and what is the relationship with those wildlife. And again, I think you got to have, you can't just talk about wildlife. That's so broad as to not be useful. So you need to talk about a particular kind of wildlife. Let's talk about whales. Whales in the United States are emotionally and therefore politically, I think, receive a high level of respect and concern. And I don't think we'll ever pass a law that says you can go back to commercial whaling, that making money is a justification of death. And so wildlife things flow with the social views of those wildlife. There's no way around it. So then that becomes the base for whatever legal help we can provide to the animals.
Thank you. I'm just going to we have one more question in the Q&A box. And Michelle, I believe this goes to you. Have you experienced personal harassment from defendants while fighting these criminal cases in court?
Yes.
It's an easy answer.
By wildlife traffickers, like people who are very well-heeled, who have a lot of money, they think it's okay to harass me. And in the Ansel case, right 2 weeks before I prosecuted Doc Ansel of Tiger King fame, I got rocks through my window at home. So yes, I have. But it doesn't deter me. I'm a tough broad, as they used to call women, and I will not be deterred.
Great, and I think that's
Can I super briefly respond to that in the civil context? So
yes,
it's equally true in the civil context. I've been named a defendant in RICO lawsuits. There's a lot of strategic litigation against public participation, trying to deter not just advocates, but their attorneys. Ringling Brothers hired the former CIA second in command to infiltrate and try to diffuse advocacy efforts. So it's definitely something to be careful of, but not to let deter us.
Yeah.
Well, and I will just echo that they keep suing me, and it is what it is. And I have a whole civil litigation department here. so you can't sue people for doing their job. I mean, you can, but ultimately it should not work. But I agree, Delcy, that's another form of harassment for sure.
Yeah. Well, this has been a fabulous panel. Thank you all so much. And that will end, I guess, our panel 3. And we're now going to take about an 8-minute break, I guess, at this point. And we'll reconvene for panel 4, which is going to focus on aquatic animals. So we'll see you back here at, it'll be 12:40 Eastern time. Thank you so much.